The Court of Appeal in London serves as the ultimate testing ground for statutory definitions in English criminal law. When the language of a statute meets the messy reality of human behavior, this court decides exactly where the legal lines are drawn. In 2005, the court heard the case of R.V.H., a dispute that required them to interpret two core provisions of the newly drafted Sexual Offences Act 2003. The facts of the case are brief. The defendant approached the victim and asked, "Do you fancy a shag?" Immediately after making this demand, he grabbed her trousers in an attempt to pull her close. The victim managed to break away. Based on that brief interaction, the defendant was charged and convicted of sexual assault at trial. He subsequently appealed the conviction. His defense strategy rested on two specific statutory loopholes. First, the defense argued that grabbing the fabric of a person's trousers does not meet the strict legal definition of touching another person under Section 3 of the Act. Second, they argued that the physical mechanics of grabbing a waistband are not inherently sexual in nature, which is a strict requirement for a conviction under Section 78. To resolve this appeal, the court had to systematically define where the physical boundary of a human body ends in the eyes of the law, and logically map how verbal context alters the legal nature of a physical act. Section 3 of the Sexual Offences Act establishes the crime of sexual assault. To secure a conviction, the prosecution must first prove the actus reus, or the physical guilty act. In this context, that means proving the defendant engaged in touching the victim. The defense attempted to establish a strict physical boundary. They contended the statute implies skin-to-skin contact, making the barrier of the victim's clothing a legal defense against the charge. The Chief Justice, Lord Woolf, delivered the Court of Appeal's ruling, systematically dismantling this defense. He laid out a definitive rule. Where a person is wearing clothing, touching that clothing legally constitutes touching the person for the purposes of Section 3. The law treats the garment currently worn by the victim as an indivisible extension of their bodily autonomy. Applying this directly to the facts of the case, the defendant's act of grabbing the victim's trousers definitively satisfied the physical requirement of a Section 3 assault. If the court had accepted the defense's premise, the implications would have been severe. Offenders could exploit thick fabrics or winter clothing to commit assaults while evading Section 3 liability entirely. With the physical act confirmed, the court turned to the second ground of appeal, determining whether grabbing the trousers was legally sexual under Section 78 of the Act. Looked at in a vacuum, grabbing someone by the waistband is physically ambiguous. It could happen during a fist fight or while trying to stop someone from falling over. Lord Woolf mandated a strict two-stage test juries must follow whenever the sexual nature of an act is disputed. First, an objective question. Is the physical touching sexual by its very nature? This requires isolating the act from its context. A grab of the trousers likely stalls at this first stage. Unlike touching a specialized intimate area, grabbing a waistband is not an inherently sexual act on its own. If the legal analysis stopped here, predatory acts that rely on ambiguous physical contact would escape classification. That makes the second stage of the test an absolute necessity. When an act is objectively ambiguous, the jury proceeds to the second phase. This is the subjective threshold. The jury evaluates whether the touching was in fact sexual based on the defendant's specific purpose or the surrounding circumstances. This brings us back to the specific verbal cue from the factual matrix. Do you fancy a shag? This aggressive verbal proposition provides clear, inescapable proof of both the surrounding circumstance and the defendant's underlying intent. This overwhelming contextual evidence clearly satisfies the requirements of Stage 2, retroactively classifying the otherwise ambiguous physical grab as sexual. The bifurcated structure of Section 78 protects innocent contact, like tapping someone on the shoulder to get their attention, from criminalization. At the same time, it traps offenders who attempt to weaponize physical ambiguity alongside their predatory intent. Slight pause. Despite outlining this strict framework, the Court of Appeal identified a problem. The trial judge in this case had actually failed to explicitly direct the jury using this two-stage test. Normally, a flawed jury direction renders a trial unfair and results in the conviction being quashed. Yet in R.V.H., the Court of Appeal dismissed the appeal entirely and upheld the conviction. This relies on the legal doctrine of a safe conviction. An appellate court can uphold a flawed trial if the substantive evidence against the defendant is so overwhelming that the procedural error becomes irrelevant to the final outcome. The paired evidence of the crude verbal demand and the immediate physical grab left no room for doubt. The court determined that any jury, even if perfectly directed on the two-stage test, would have inevitably reached the exact same guilty verdict. For legal practitioners, this case leaves a dual legacy, providing clarity on both the physical act requirement and the intent elements of sexual assault. RVH definitively rules that a person's physical boundary includes the clothing they wear. Furthermore, it establishes a clear logical test, proving that context is the ultimate adjudicator of sexual intent.